The debate on abortion has been a constant back and forth since the ruling of Roe v. Wade in 1973. Today, I'm going to add on to that through an article that was posted by the New York Times editorial board discussing the 20-week Arizona ban and how the Ninth Circuit Court of Appeals struck it down and the Supreme Court did not review it. So today I'm going to refute the idea that this was a good idea for the Supreme Court not to review it. And we're going to look at the meaning behind Roe versus Wade, the idea that states should have the right to limit when abortion is accessible, and the threat to both the mother and child of abortion after 20 weeks. So to begin, the main claim of the article is that the Supreme Court made a good call by not reviewing it, which is a huge step for pro-abortionists, but not pro-lifers, obviously. Roe versus Wade was passed on the condition of health, not on convenience, which is what a lot of pro-abortionists are fighting for now. Roe was a pregnant single woman who brought a class action suit challenging the constitutionality of the abortion laws because the law made it a crime to obtain or attempt abortion except on medical advice to save the life of the mother. And this is all information from the Roe versus Wade case brief summary found online. The court did not grant complete freedom for women or doctors to abort babies, but instead it ruled that in the first trimester that the doctor would put forth its decision and judgment on if the woman should abort. The second trimester, states can promote their interest in the mother's health by regulating abortion procedures, and then in the third trimester, states can promote their interest in potentiality of human life by prohibiting abortion, except when necessary to preserve the life or health of the mother. So this court decision at no point gives free rein to women to abort a child anytime they want without justifiable reason, and is rather based on the intercession of professionals in the law. This shows that while abortion is no longer a criminality, it's not meant to be abused. And so moving on to the next point is that states should then have the right to limit when abortion is accessible. Again, going back to the case of Roe versus Wade with the second trimester and the state's intercession, this shows that many have overlooked this statute, and as a result, abortions have strayed wildly from the precepts that were set by the Supreme Court in the original ruling of Roe versus Wade. Roe saw the right to abortion as a liberating act, a good in and of itself. However, according to an article called Aborting Roe, today, more than 30 years later, there's significant evidence that the practice of abortion has wrought great harm upon thousands of women who chose, much to their regret, to exercise their rights of abortion under Roe. And so if this is based on evidence causing more harm than good, then states should have the right to intercede and fight for the health and protection of the women in their states. Finally, there are many health dangers that come with allowing abortions after 20 weeks, not only to the growing fetus, but to the mother as well. And this is shown through several articles from Conception to Birth, A Life Unfolds, Doctors on Fetal Pain, and an article by Von de Velde. And so these show that a fetus has functioning organs, and so we can likely assume that the fetus can feel pain to begin. Research shows that by the end of the second month, the fetus's heart is beating at 20% the rate of a full-grown human heart, and all its organs are functioning. As further proof, many medical experts have shown that at 20 weeks, even before the 20 weeks, the child does not need the functioning cortex to experience pain, and so the lack of those being attached does not by any means mean that the fetus cannot feel pain, but in fact there's been proven facts that it can be, and that pain is felt. Continuing by 8 weeks after fertilization, the unborn child reacts to touch. After 20 weeks, the child reacts to stimuli that are recognized as painful if applied to an adult human. Pain receptors are present throughout the child's entire body by no later than 20 weeks fertilization, and nerves link these receptors to the brain's thalamus and subcortical plate by no later than 20 weeks. For the mothers, at 12 to 13 weeks gestation, according to Women's Health Defense Act, the physical complication rate is 3% to 6%. But the complication rate increases to 50% or higher as abortions are performed later into the second trimester. Live birth abortions are often the result of current national policy to permit late abortions. One is the gruesome January 2011 report describing the deaths of numerous infants, and Dr. Kermit Gosnell, who faces murder charges in the deaths of one woman and 7 late-term babies whose spinal cords were severed after they were born alive during abortions. So this shows detrimental consequences to both mother and child. So, in conclusion, the editorial contained many subclaims supporting the belief that the Supreme Court made a good decision in not reviewing the Arizona law. However, I disagree completely. This is shown through identifying the main claim as well as supporting subclaims. And these show that Roe v. Wade was not passed for convenience. States should have the right to limit when abortion is accessible, and many dangers abortion can bring to both women and the fetus. So in conclusion, abortion will likely continue to be an ongoing debate until the Supreme Court reaches a less abstract conclusion. However, this speech was designed to give a look into the way states can regulate abortion effectively and promote the health of the common good.